Now, once again, Raymond Arroyo.
Welcome back to The World Over Live. With the Supreme Court's landmark decision in the Obamacare case and legalizing same-sex marriage, how might religious liberties be impacted? And what does the reasoning behind these rulings really tell us? To analyze, I'm joined by the original lead counsel for the Hobby Lobby religious freedom case, formerly of the Becket Fund, attorney Kyle Duncan. Kyle, thanks for coming back.
Thanks for having me on.
I want to ask you in the macro here, as you look at all the rulings or the majority of the rulings we saw this term from the Supreme Court, what does the legal reasoning that you saw there in those decisions tell us about the direction of this court and the mindset?
It's hard to sum up an entire term in one quote, although I think I'll try. The Chief Justice of the Supreme Court, John Roberts, in his dissent in the same-sex marriage case, said something striking to me and a little poignant. He said, "Just who do we think we are?" And I think that summarizes sort of the feelings that many have, maybe some on the court have, about the court's work. It's a sense of not fully understanding what the role of the court is in our constitutional democracy. Is it an umpire calling balls and strikes, as Chief Justice Roberts said in his confirmation hearings? In other words, neutrally applying objective rules of law, regardless of the particular outcome,
or case.
Or is it becoming more of a political body that picks and chooses certain preconceived results, certain policy outcomes that certain justices think are desirable over others, and achieves the result through reasoning that may not seem terribly persuasive to some people? So I think who is the Supreme Court and what is its role in our constitutional democracy is a question that's raised by some of the big decisions this term.
Let's get into some of them. This is a little bit from Judge Roberts' majority opinion in the King versus Burwell case, the so-called Obamacare case. He writes, "In a democracy, the power to make the law rests with those chosen by the people. Our role, the courts, is more confined to say what the law is. That is easier in some cases than in others. But in every case, we must respect the role of the legislature and take care not to undo what it has done. A fair reading of legislation demands a fair understanding of the legislative plan." So in that case, just to remind people, and you can shed some light on this too, they found language in the law that really wasn't in the law. The law required that if a state set up an exchange, well, then they could be, the people could be beneficiaries of this, what do you call it?
The subsidies, the tax credits. Right.
But if they didn't set up the exchanges, if the state didn't set up an exchange, then no subsidies could come to those individuals. The Supreme Court said, you got to interpret what they meant.
That's right, Raymond. The words that Congress actually put down in the statute required that subsidies could only flow through an exchange established by a state, not by the federal government, not by the federal HHS, only an exchange established by the state. That was language deliberately chosen by Congress. And Congress, of course, assumed that states would set up exchanges because Congress gave them incentives to do so. But the problem was at 34 or something like that, states did not. And so the question is, what is the Supreme Court going to do with that? Is it going to interpret the words established by a state to be established by a state or by the federal government or by the HHS? And that's what the majority of the court actually did.
Here's what Justice Scalia said in his dissent. He wrote, "Today's interpretation is not merely unnatural, it is unheard of. Who would ever have dreamt that, quote, exchange established by the state, end quote, means exchange established by the state or the federal government? Little short of an expressed statutory definition could justify adopting this singular reading. We should start calling this law SCOTUS care." Your reaction?
My reaction is that Justice Scalia has always been a champion of textualism, of actually reading the words and applying the words that Congress has given the court, because that's important to separation of powers. Frankly, the court doesn't legislate. The court only interprets and applies law. It doesn't legislate. And if it gets into the business of interpreting laws in one way because it perceives that Congress might have wanted this particular outcome, the court starts shading into legislation, legislative power and not judicial power, and that's a real problem for Justice Scalia. I think it's a problem for the Chief Justice as well. And in this case, he obviously struggled because his majority opinion says that, the plain meaning of the provision, quote, arguments for the plain meaning are strong. He admitted in his majority opinion, and yet he interpreted those words in light of what he perceived as the overall purposes of the act, and I think that's what drew the sharp criticisms from Justice Scalia.
Well, here's the thing where you have to connect the dots on this. In the Burwell King case, Justice Roberts says, look, we're interpreting it this way. Then in the gay marriage case, in his dissent, he decries the Supreme Court finding new laws or discovering things. But that's just what they did in the majority opinion in the Obamacare case, in both of them. They discovered new language, new meanings, created what was a fee is now a tax. I mean, it does sort of boggle the imagination after a time. I want to read this quote, get your reaction. Sure. Justice Kennedy wrote in his majority opinion of the gay marriage case, Obergefell versus Hodges. He writes, saying that there is an equal protection at play here. The right to marry is a fundamental right inherent in the liberty of the person. And under due process and equal protection clauses of the 14th Amendment, couples of the same sex may not be deprived of that right and that liberty. Now, Justice Roberts, who we just spoke about a moment ago, wrote in his dissent to the same opinion, if you are among the many Americans of whatever sexual orientation who favor expanding same-sex marriage, by all means celebrate today's decision. But do not celebrate the Constitution. It has nothing to do with it. Here's my question. Have these two decisions taken in tandem, do they stretch the Constitution out to the point that it becomes silly putty, where we're finding now a right to dignity? Is there a constitutional right to dignity?
I think the question raised by both of these decisions, but especially by the same-sex marriage case, is whether the court is actually applying neutral principles of constitutional law. It raises a question about the legitimacy of the court. And I think Chief Justice Roberts raises that question and some of the other dissenting judges. And by legitimacy, I think they mean, does the public perceive the court as a neutral body that is applying principles of constitutional law that it actually finds in the document? And in the document, in the text of the document, in the context, in the history of the document? Or is it inventing rights because it perceives that this is a good idea? And that's what Chief Justice Roberts is saying, as well as Justice Scalia, Justice Thomas, and Justice Alito. And I think that raises serious questions about the legitimacy of the court. And by legitimacy, I don't mean that people are going to rush out and not obey the court's decision, because you don't see that happening. I think it's very important to our constitutional democracy that people respect the court, that respect the decisions the court's making, that respects the process through which the court is making decisions. After all, we don't vote on the members of the court. The members of the court have immense power. They are appointed for life. We have a great institutional respect for the court. And I think some of the things that Chief Justice Roberts and others are saying in this case is that they're concerned that the court is resolving an issue on which so many Americans disagree.
Well, weren't you astounded by the scope of this? I mean, they could have very narrowly said, look, in some states this is legal, in others it isn't. You could have even said, if you're married in Massachusetts, it has to be recognized in other states, but those other states don't have to play host to nor grant marriage licenses. Why didn't they go down that path?
Well, of course, I don't know why they didn't go down that path, but you're right, Raymond, that the decision is sweeping. What the decision essentially says is that it's a matter of substantive due process, which is a part of the Constitution that's not actually written in the Constitution, but is a part of our, let's call it our fundamental commitments in our nation. The court has found that gender cannot be part of the institution of marriage, so that the definition of marriage that was embraced by every state since the beginning of the country until 2003, well over 200 years, the court has now declared that to have been unconstitutional, or at least since 1868 when the 14th Amendment was adopted. That's a profound thing that the court did, and it's sweeping. And I think those who are concerned about the breadth of the court's decisions have good reason to be concerned, and good reason to be concerned about what this means for the rights of dissenters going forward.
We were talking before the show. How does this compare to the EU's position on marriage?
So the European Court of Human Rights has had a couple of cases on this and has decided that the nations of the European Union need to be allowed to go whichever way they want on this issue, because this issue is one that's profound, that arises from culture. It's profoundly sensitive, it's profoundly difficult, it's profoundly divisive, and so even the European Court of Human Rights has seen fit not to impose this on all the nations of the European Union, and our court in the United States has now gone, let's say, to the left of that. So that's striking.
What do you believe this portends for religious liberty? I heard today an interview on C-SPAN radio with one of the leaders at Lambda Legal, which is a gay rights legal shop. They wish to move forward expeditiously with protections, gay rights protections for housing, employment, and public accommodation. What does that mean?
Well, I think in their terms they would call it full equality. They want gays and lesbians to be, to have every protection known to the law, so that, for example, if we all know the case of the wedding photographer. If a wedding photographer says, "Look, I have a conscientious objection to participating in a same-sex marriage," the folks on that side of the debate want essentially gay and lesbian rights to be equated with race, essentially, so that it would be, it would be totally and completely unacceptable, both as a matter of law and as a matter of sort of social policy, for anyone to object to same-sex marriage. Now, to be fair to the Supreme Court did include some few sentences about the rights of the First Amendment rights of religious objectors, to religious dissenters, to teach and advocate.
Now, but doesn't that mean within the four walls? That's what it increasingly sounds like.
I think the concern here is that it was framed in narrow terms, which Chief Justice Roberts pointed out, that we don't have a teach and advocate clause in the Constitution. We actually have a written clause in the Constitution that guarantees the free exercise of religion, and that we should be concerned if the Supreme Court seems to be cutting back on that in this particular realm, where there's such cultural, political, and frankly economic power on the other side to punish dissenters.
I have to ask you about another case. I know you've been intimately involved in a similar case in Louisiana. In Texas, the Supreme Court let stand a stay that kept an abortion bill passed by the Texas legislature, signed into law, from going into effect. What does it essentially say? What is at risk here?
The laws in Texas, and they're being litigated in other states as well, including Louisiana, they essentially do two things. They require outpatient abortion providers to have admitting privileges at local hospitals, meaning they have to have privileges to be able to admit their patients who undergo complications that require hospitalization. That's common in many states that have been litigating. Texas adds that the outpatient abortion clinics have to satisfy the requirements for ambulatory surgical centers in their physical plant and whatnot. And so this law in Texas has been litigated. It's gone up and down to the Fifth Circuit in the U.S. Supreme Court several times. It seems that if the law went into effect, it would shut a number of abortion clinics in Texas. It wouldn't reduce them completely, but it would reduce them to something like 7 or 8 abortion clinics. The Fifth Circuit, in a resounding decision, upheld the operation of that law. And what the Supreme Court has done is essentially put that law on hold while the court decides whether to take the case. I think we shouldn't read too much into that.
That's what I was going to ask you. I mean, by a majority, they decided to hold the law, which is what a lot of the abortion providers wanted, claiming that this is a violation to a woman's right to have an abortion. Her right to privacy is being violated here.
That's right.
And access to an abortion.
Right. And of course, on the other side, what states like Texas and Louisiana, and I represent Louisiana in this case, are saying is that no, this is a common sense provision to protect women's health and safety. That if women who undergo complications in abortions, and it's admitted that women do undergo complications that sometimes require hospitalization, that it's better for the patient, for the doctor to be able to admit the patient to the hospital. This also protects the integrity of the medical profession because by requiring privileging or credentialing at hospitals, we're able to check on the background of the doctors and make sure that they're providing good medicine in these clinics. And so what we have here is a health and safety regulation that's pitted against the so-called right to privacy. And the Supreme Court is going to have to work this out, whether it does in the Texas case, a case from Mississippi that's currently also pending in the Supreme Court, or the Louisiana case, remains to be seen.
Okay, I want to put somebody, as we have 2 minutes left, I just want to kind of put this in some context. As I look at the cases and I read through the findings and the rulings, and I casually read these, not the way you do, One comes away, and I came away thinking of that 1996 symposium that my friend Father Richard Newhouse hosted in First Things. And it was called The End of Democracy, the Judicial Usurpation of Politics. Is that what we're facing here? See, and I'm not arguing about the issue or even the way they were decided. People are going to come down at all different sides on these things, whether it's Obamacare or it's gay marriage. I'm concerned about the reasoning or non-reasoning of this court arbitrarily creating rights and dreaming up new provisions or seeing words that aren't there. Doesn't that undermine our freedoms and the democracy and this republic as an experiment?
Well, Raymond, I think we should be concerned about who rules us. And Justice Scalia said this very well in his dissent in the marriage case. He said it wasn't a particular concern to him what marriage was in the law, but what was of particular concern to him was who ruled him. And it seemed to him that the 5 justices on the Supreme Court had sort of declared themselves the rulers of 320 million Americans on this issue, the definition of marriage that has always been thought to be a fundamental issue for the citizens of the state. And if the Supreme Court can usurp that, that's your word, can blow by that, and say, we're going to tell you what marriage means, we're going to tell you what the direction of marriage is, then the question is, on what issue could they not say that? No. And as I sit here with you, I can't think of one. So I think we should be concerned.
Compare this very quickly, because we still have 1 minute, Counselor. How do you compare, there are people who say, oh, this is the end of Christianity, we're under persecution. As you look at the international scene and how people are being treated abroad, compare what we're facing in this country to what other people are facing.
Raymond, as you know, you're going to have some guests on to talk about the situation of Christians in the Middle East. And those people are facing dire and horrific persecution. Mm-hmm. We are not facing that in the United States. And we should be grateful for that. What we should do is recognize that we have the blessings of liberty, and we should try to keep them by recognizing, again, who rules us, and whether we should maybe rule ourselves on some issues. So we're not being killed like so many Christians in the Middle East, and we shouldn't pretend that we are. Yeah. But we should perhaps find some courage to actually profess what we believe as Catholics, and to fight for the same principles that our founding fathers fought for, which is the ability to rule ourselves.
Kyle Duncan, thank you for being here.
Thanks for having me.
We'll be in touch.